With so much hype and criticism on the COVID bill, one just can't ignore its impact, or the lack of it, during such times of uncertainty. If you have no clue how the COVID bill can benefit you, well, here's a Merdeka present for you. To encourage us to make more videos like this, please like, share and subscribe. We will really appreciate it. Thank you. Malaysia has recently tabled the temporary measures for reducing the impact of coronavirus disease 2019, Bill 2020. The purpose of the bill, and eventually an act, is to help alleviate contractual issues and to provide certain adjustments to the existing laws during the movement control order period starting from 18 March 2020. Here is the gist of it. If one is unable to perform a contract specified in this list due to the measures taken pursuant to the Prevention and Control of Infectious Diseases Act 1988 to prevent the spread of COVID-19, the other party cannot hold such non-performance against the non-performing party. For example, if one is required to supply certain products within 14 days from the date of the contract. However, due to the movement control order, the supply of the products is delayed. The other party shall not use this as a reason to claim breach or to penalize the non-performing party. Notwithstanding that, the COVID bill subscribes and favors mediation as a mean to resolve any dispute arising from such circumstances, which we think is a prudent move to help the parties to resolve the dispute with a lower cost option. However, the downside to this COVID bill is that it will have no effect on contracts terminated or legal proceedings commenced prior to the publication of this act. Hence, one of the criticisms of the bill is that it is a little too late. A limitation period is a period of time where a party must bring a claim during that period, failing which, he is barred to bring the claim. For example, the limitation period for a breach of contracts is 6 years from the date of the breach. Hence, if the breach occurred on 18 March 2014, the last day to file a legal action is on the 18 March 2020. The COVID bill provides an extension of the limitation period to 31st December 2020 if the expiry falls on 18 March 2020 to 31st August 2020. This is only applicable to limitation periods specified in these acts. Apart from what was earlier mentioned, the COVID bill intends to make certain modifications to the following act. The material changes are as follows. In the Insolvency Act 1967, the minimum debt threshold to bankrupt a person is now increased to 100,000 instead of 50,000 ringgit Malaysia. In the Hire Purchase Act 1967, no owners shall now repossess any goods in a hire purchase agreement for any default in installment during the 1st of April 2020 to 30th September 2020. Under the Consumer Protection Act 1999, where the purchaser shall fail to pay his installment, he can elect to pay the overdue installment without there being any late payment charges, and the credit facility provider cannot commence legal proceeding against the purchaser. However, this will only apply if the credit sale agreement was entered before 18 March 2020 and there are no prior overdue installments. In the Distress Act 1951, the landlord shall not recover rent by way of a warrant of distress for a rent in areas during 18 March 2020 to 31st August 2020. Under the Housing Development Control and Licensing Act 1966, when calculating time for delivery of vacant possession, liquidated damages, and defect liability period, the period of 18 March 2020 to 31st August 2020 shall be excluded. As for the Industrial Relations Act 1967, when calculating time to file a representation and for a claim for recognition, the period of 18 March 2020 to 9 June 2020 shall be excluded. Similarly, in the Private Employment Agencies Act 1981, when calculating time for an application to renew the license, the period of 18 March 2020 to 9 June 2020 shall also be excluded. In the Land Public Transport Act 2010, a licensed operator of a public service vehicle, tourism vehicle, or goods vehicle can apply for a period of at least 12 months for the use of the said vehicle as public service vehicle, tourism vehicle, or goods vehicle. Similarly, in the Commercial Vehicles Licensing Board Act 1987, any holder of Public Service Vehicle License, Carrier License C or A vehicle can apply for a period of at least 12 months for the use of the said vehicle as public service vehicle or goods vehicles. Under the Courts Adjudicature Act 1964, Subordinate Courts Act 1948 and Subordinate Courts Rules Act 1955, instead of getting approval from the Rules of Committee, the Chief Justice can now issue any direction relating to the business of the court or modify the rules of court as she deems necessary in the dispensation of justice, public safety, public security, or general public health. As mentioned earlier, the downside to this COVID bill is that most parts are not applicable if a legal proceeding is commenced prior to the publication of this Act. A disgruntled creditor can choose to quickly initiate a legal proceeding before the publication of this Act in order to defeat it. So, how effective is a COVID bill then? Are we a little too late as compared to other countries? When will it be enacted then? Notwithstanding that, we believe that late is better than never. In any event, there is still possibility that there will be some amendments made prior to it being enacted as an act. So, now you know what the COVID bill is all about. What are you going to do about it?